Hello, welcome everybody. Welcome to our Material Digital Humanities seminars for today. There's plenty of people in the room and we are recording the seminar. Our guest for today is Professor Chijioke Okorie. She's Associate Professor from the University of Pretoria. And the topic of the seminar is Digital Treatment of African Cultural Heritage, Shifting Landmarks and Implications for Copyright Exceptions for Archives. For those of you who are new, or maybe this is your first time attending the seminar, the Material Digital Humanities seminars are a recurring event that this year is being presented by myself, Chiara Palladino at Furman University, and by Professor Gabriel Bodard at the University of London Institute of Classical Studies. And if you would like to have an idea of the upcoming events and what is coming for the Digital Humanities seminars, there is a link to the STOA page, which I'm going to post in the chat as well. And there is a link to the series of seminars and the abstracts in the page of the School of Advanced Studies of the University of London. With that being said, as you know, just a reminder that this meeting is going to be recorded, and I would ask everybody to keep their camera, their video and the audio off for the whole duration of the seminar. We're going to allow for some questions at the end. We're hoping to have 20 to 15 minutes for a discussion after the end of the seminar. And if you want to be removed from the recording, please shoot me an email or contact Gabi Bodard at the end. Okay, with that being said, it is my great pleasure to have our guest, Chijioke Okorie, presenting at today's seminar. Chijioke, the floor is all yours.
Thank you so much, Chiara. I'm going to share my screen and then we can get started. Okay. Hi, everyone. Chiara has already introduced me. I'm Chijioke Okorie. I'm an associate professor at the University of Pretoria. I also run a research group called Data Science Law Lab at the University of Pretoria, focusing on research that provides evidence for policy making and activities generally that enable people that work with data, that enable data science research from an Africa perspective. So the topic of my presentation today is a mouthful, but I have deliberately left it as is because I think that it's encapsulates the conversation that I want us to have today about digital treatment of African cultural heritage, and looking specifically at that issue from from the perspective of landmarks. So this is from a chapter that I contributed to a book volume that was edited by Gabi and Chiara in 2023. And so it's been, after writing that chapter, there was also, there were also things that has happened that I think is also reflective of some of the arguments that I put forward in that chapter, but also beyond that, also, provide some context for what the future looks like when you think of digitization as it relates to cultural heritage, especially from, an Africa perspective. And another thing is why landmarks. Landmarks was the lens through which I started to look at this issue of digital treatment of African cultural heritage, because it was the theme of a conference that was held by the International Society for the History and Theory of Intellectual Property, ISHTIP, I think in 2020. okay, was supposed to hold in 2020, but COVID and then 2021. But it became, for me, Landmark was, I was looking at it from the perspective of a foundation or a point of something that guides how you approach a destination or how you approach a journey. And in this case, the journey would be, how do you handle digital treatment of African cultural heritage, looking at existing landmarks, looking at existing guiding points, and then deciding whether they are sufficient or appropriate when it comes to digital treatment of African cultural heritage. So the starting point for me is that you look at archives and archival institutions in this case, and how they deal with archival materials. And everyone is cognizant of the fact that information and communication technologies, development in that space has really shifted archival management from paper to digital. So at every point in time, you're not just looking at material cultural heritage, but you're thinking of what they would look like in digitized form, and how the digitized form or digital treatment thereof enables access or increased access to material cultural heritage. But one of the things, again, is that with the new digital environment, you then have higher expectations of access and preservation. And I will come to access and preservation because they are the existing and popular landmarks for how you then decide what kind of legal frameworks or legal strategy would be adopted to enable access, to enable preservation of material cultural heritage. And specifically in the copyright space, you look at copyright exceptions as the go-to mechanism for addressing the new digital environment and ensuring that memory institutions like archival institutions, libraries, museums, and so on and so forth continue to play the role that we need them to play in enabling access to materials that might otherwise be that would be copyright protected, but that might otherwise be limited in terms of accessibility or how people are able to access and use those materials. One of the materials that has also guided my thinking in this space has been the 2019 Statement on Intellectual Property Rights and Open Access for African Cultural Heritage that was drafted by Parvis and Wallace, Mathilde Parvis and Andrea Wallace in 2019. I was one of the scholars that signed or supported that statement, because the statement basically was addressing mainly what the French government had come up with in the Savoy report, where they were putting out the logistics, I would say, or the thinking around how they intend to deal with repatriating cultural heritage that were looted or stolen from the African continent, during colonial times, and wanting to repatriate those material cultural heritage to the relevant African countries from where they were forcefully taken or stolen, as the case may be. And one of the things in the Savoy report was that to enable access to those materials, to continue to preserve those materials, that it would be necessary to digitize those materials before they are repatriated to the relevant countries. And Parvis and Wallace make the point, with my support and with support of other scholars who signed on to that statement, to say that the conversation around digitization prior to repatriation should not happen in isolation of the relevant communities who actually own those materials. So because, for so many reasons, but one of the key or some of the key reasons for that position is that when you digitize, then you would be creating new materials that could be subject of separate, distinct, rights of ownership, of custody, of control, and including, copyright. So, for example, if you take a photograph of a material cultural heritage object, for example, you would start to think about who would own copyright in the photograph. It would, in the absence of specific contractual arrangements, it would be the photographer. And then you've created, these new materials, created these new rights, brought in additional stakeholders without even thinking or engaging with the local communities that actually own those material cultural heritage objects. So that's one of the key works that influenced my thinking in this space. Now, when it comes to landmark, I've already explained how I started to look at landmarks in the way that they offer you a way to look at how we enable archival institutions and other memory institutions to do their work, and how we see their role when it comes to cultural heritage. So the core landmarks has always been that these are institutions that preserve cultural heritage, that safeguard cultural heritage, that provide access to cultural heritage. And so when we look at how copyright exceptions in favor of those institutions have been couched, it has always been that we want to enable them to reproduce materials for preservation. So you think about material cultural heritage objects, and then you say to yourself, if we leave this material in the form that it is, there are several limitations in terms of the number of people that can access and use those materials at any given point in time. And for the continuity of culture in that context, you also want to keep the materials in their original form, but still make provisions for multiple people in different places at different places at different times to be able to access those materials. And so copyright exceptions for memory institutions, including archival institutions, has always mostly been about reproducing, giving them creating exceptions that allow them to reproduce materials for preservation. And then obviously when those materials are reproduced for preservation, they also then enable increased access by more people at different times, at different places. But then I've already talked about the fact that you then in the process of reproducing materials, depending on your choice of reproduction medium, you could be creating digital surrogates of those material cultural heritage objects, and they could then be subject of their own copyright protections, leading to additional conversations about how to ensure that balance between the interests of the now copyright owner of the newly created material and users who would want access to even those materials in the digitized form. So the emphasis has been on you're looking at physical preservation, you're looking at digital access in that space, and those have been the traditional landmarks that you use to engage with the role of memory institutions, including archival institutions. But there are challenges with the traditional, approach of looking at preservation and access as the dual or twin landmarks or frameworks that we use to engage with memory institutions and their roles and exceptions that enable them to engage with their roles. And because when you think about preservation and access as the leading or as the sole framework through which you look at these things, it has led to looting, it has led to exclusion of the local communities that are in fact the creators and the owners of the relevant material cultural heritage. And I say this because when you engage with news and even the conversation around repatriation of cultural heritage that had been looted in the past, it has mostly been a question of we want to preserve this culture. We want to provide access, for people to engage with previous civilizations and way of life of the African people, helps the African people to continue to maintain their culture for future generations. And there's always this worry also about if we then repatriate these materials, how sure are we that they are going to be preserved and there's still going to be continued access by other people to those materials when they get into the country of origin. And so there's preservation and access, as frameworks, as landmarks has also, generated those kinds of feelings around, we want to protect this, we want to preserve, we want to create access. And that has happened in a space that then ignores issues of community representation and community agency of the very people that created those materials and that should exercise rights of ownership and custody of those materials. Digital reproduction also transcends borders, and that also complicates issues around, copyright and control. And so I started to say so my arguments, or one of the things that I then put forward in that chapter, and which has also guided the work that I have continued to do in this space, is that there's need for not a new landmark in the sense of a landmark that would shift that of preservation and access, but in terms of thinking about agency as a complementary landmark that would a complementary landmark, sorry about that, a complementary landmark that would also operate side by side with the landmarks of preservation and access. And one of the things is that agency, of course, is the ability of individuals or institutions to act independently and make their own choices in relation to managing cultural heritage material. And so when you then think of preservation and access in addition to agency, it then means that you need to then rebalance power between the institutions that are handling material cultural heritage, whether in digitized form or in physical form. The institutions that are handling that, rebalance power between them and the indigenous stakeholders, that is the local communities. So agency emphasizes active participation and control by cultural communities. One of the things with the whole repatriation conversation has been that the focus has largely been on the institutions or the countries that are repatriating, that are returning material cultural heritage, and also then looking at the institutions or national agencies that would then receive the repatriated material. There's not a lot of conversation around what then happens when at the national level those materials, the repatriated materials, are received. And I used the Nigerian archival, the National Archives of Nigeria as a case study or as an example to explain, how the lack of agency as a landmark is really problematic. When you look at the National Archives in Nigeria, you would find that it operates as a relic of colonial times, in the sense that the way that the governing board of the institution is set up, the way that the management of and the running of the agency is set up, is not conducive to to input from local communities that might be involved from time to time in relation to specific material cultural heritage objects. So take, for example, Bini bronzes. The Bini kingdom was used to operate as a separate cultural community, right? During colonial times. Post-colonial times, this has now become part of a state, a province, depending on whatever you might want to call it, but a unit of, or part of the federal government of Nigeria. And so there's every possibility, and that has even happened in actual fact, that there will be influences from the national government, from the federal government, from the state government, in relation to how Bini bronzes, for example, Bini mask and material cultural heritage from that tribe, from that community, will be managed, will be preserved, will be digitized for people to have access to. But there's not that engagement with the input of the local communities that created those bronzes in the first place, and that continue to create them even in these times. So with the landmark of agency, the conversation is around supporting the preservation of cultural heritage in a way that takes cognizance and prioritizes input from the local communities in terms of how the digitization should happen, and how access and preservation should happen post this digitization. One of the things that you would find if you are able to engage with the entirety of the book volume that was edited by Chiara and Gabi, is that the various chapters in that volume speak to different issues around material cultural heritage, and including digital treatment thereof. And one of the things there has been that when you digitize, there are decisions that are made about what is digitized, how, what, and there might be possibility, there are possibilities that context might be lost or added in the course of digital treatment. And so it would always lie on the person digitizing or taking or handling or guiding the process of digitization to decide what context follows through from the material cultural heritage object to that object in digital form. And so undertaking digital treatment or digitization without enabling and allowing and empowering the agency of local communities then ensures that we lose a lot of context, and we disempower those local communities to the detriment of the materials that we set out to preserve in the first place. So preservation is not just about the physical material in its form or the material cultural heritage in its form, but preservation would also be about continuity and about the context of the local communities involved, and how that is taken forward. I've already spoken about Nigeria's National Archives and its mandate and its structural limitations, and especially its institutional design in terms of the people that make up that agency itself, and how they are involved in managing cultural heritage, and how continuing in the path of not recognizing the agency of relevant local communities, indigenous communities, could undermine, agency in managing cultural heritage. But what are the implications for copyright exceptions? I've already spoken to the fact that copyright exceptions as for memory institutions have largely focused on reproduction for purposes of preservation and access. But then with the recognition of the need to have the complementary landmark of agency, it then means that we have to then start thinking about how copyright exceptions are taken forward in this space. One of the things one of the examples that provide some food for thought, at least, is South Africa's approach to indigenous knowledge and how it has laws that recognize the local communities and define them in a way that make them easily identifiable, and then which then carries forward that recognition and respect for the agency of local communities when it comes to dealing with indigenous knowledge, cultural heritage, and cultural materials, as the case may be. And so I have then called for a radical reimagining of archival practices in post-colonial context, to think about, from an institutional design perspective, how the agencies that are going to be in charge of receiving repatriated cultural heritage materials, agencies that are going to be in charge of determining making decisions around digital treatments of those materials, how they should be structured in a way that allows them to naturally recognize and value and actually bring in input from local communities, thereby centering their agency and their involvement in their own cultural heritage materials. So there should be emphasis on co-custodianship as opposed to this whole the current practice of having decisions of around material cultural heritage only taken from a national perspective. And when we do this, it then prepares these institutions for the new, would I say, wave of copyright limitations and exceptions in the digital age. One of the examples then, that brings to life these issues that I have just touched on is the Marrakesh Treaty that establishes copyright limitations and exceptions specifically for persons with visual impairment. One of the things that has happened in South Africa is with the decision of South Africa's Constitutional Court in blind essay against the Department of Trade, Industry and Competition and others. The matter related broadly to copyright legislative reform that has been ongoing in South Africa since 2015. But for purposes of our conversation today, one of the things with the decision of the Constitutional Court was that the Constitutional Court felt the need to recognize the persons with visual impairment or visual disability, and how not recognizing their agency and their issues around the way that copyright operates in terms of access, in terms of use of copyright protected material, how that lack of recognition really affects various constitutional rights that those category of society also enjoys, like everyone else. And the points that one of the key points that the Constitutional Court then made was to say that to treat access to copyright materials as if everybody and any person can access copyright protected materials the same way is highly unconstitutional, and that what should be the case is that there should differently situated people should be treated differently so that you achieve equitable outcomes, so that you achieve outcomes that are in fact constitutional. So the point of and how this relates to our conversation is from the perspective of then saying, if we do not recognize the agency of local communities to have a say, a meaningful say in how their material cultural heritage is digitized or is treated from a national perspective, is really challenging, is really problematic for achieving the appropriate role of memory institutions. There was a fire in the University of Cape Town that affected a significant number of cultural heritage materials that were held in one of the main buildings at UCT that was affected in the fire. And that demonstrated the value of digitization for safeguarding access. So the point is not that digitization is a problem in and of itself. The point is not that preservation and access are in and of themselves problematic landmarks for how we think about copyright exceptions for memory institutions, or how we think about the role of memory institutions. No, the point is that in and of themselves, or by themselves instead, they are limited, and they can exacerbate existing inequalities and related negative issues. And so to complement those landmarks, we need to have agency also as a guiding principle, as a guiding foundation for how we look at the role of memory institutions. And then one of the things that then has advanced from the chapter that I wrote, that I referred to, is the work around African natural language processing, and thinking about licensing and copyright exceptions that enable work in that space. Again, in that space, one of the things has always been, okay, how are we creating or establishing copyright exceptions, or how have we structured copyright law and other laws and other legal frameworks that should enable access to data that would enable work in the African natural language processing space. And again, in that space, if we then focused on that we want to preserve African languages, we want to provide access to African language materials because it also speaks to our needs as Africans, or speaks to the context of the African people. If we just focused on preservation and access, we would be also making a mistake in that space. And so it becomes important to also consider agency of the local communities that provide access to their culture, to their language data, that then enables work to happen in the African natural language processing space. So all of these cases underscore that need to balance preservation, and access with active participation, agency of local communities. And so starting to round up now, a dual, landmark approach is proposed in terms of looking at preservation and access, yes, but also agency of local communities. And then to think about repatriation and decolonization, when it comes to, material cultural heritage and cultural heritage conversations generally, decolonization has to and does go beyond repatriation. It requires, dismantling colonial control in heritage management. And that's why I spoke of receiving entities in the countries where these, when it comes to repatriation, where these materials are going to then end up. You then have to involve local communities in how you manage those materials when they come to their country of origin, and that the traditional focus on preservation and access is insufficient and problematic. when we don't then also recognize community agency. And effective copyright exceptions must integrate, both institutional mandates and local cultural rights. That is, the agency of local communities. And in conclusion, digitization, of course, offers transformative benefits, but it also brings about, legal and ethical challenges. And shifting from a solely preservation access model or our approach to also the complementary approach of agency is very critical, and that institutional reforms must also return control and decision-making power to indigenous communities. And I've already spoken about copyright exceptions and copyright policies and how they need to be inclusive and transparent and involve, co-design and co-custodianship and collaboration with local and cultural stakeholders. Thank you, and I'm looking forward to questions and comments. Thank you.
Thank you very much, Chijioke. Let me just switch to gallery view. Thank you very much for this amazing talk. And it looks like we have a full room and a full chat already. So we may as well start our conversation from that. Once again, a reminder, if you would like to ask a question, you can post it in the chat at this point, or if you just use the emoji for the hand to signal that you would like to ask a question in live in video, please do so, and I will make sure to give you the stage. So we have the first question from Martin Newman in the chat. Martin, would you like to pose your question on video, or would you like me to read it out loud?
Hi. Yeah, I'm quite happy to. I was interested in the concept of very interested in the concept of when creating a digital copy actually creates new intellectual property. And in EU and UKE copyright law, it's almost a case of it has to be intellectual, artistic input. All of that. So, if, for example, it's something that's two-dimensional and you create a digital facsimile, you will never create new copyright or intellectual property right at all. But if it's two-dimensional, then you can. But you've got to have some sort of input there in the way you positioned, you've lit, etc. And if there's not that, then the digital remains exactly the same copyright and intellectual property as was vested in the original, which works very well, I think, for sort of more modern items and artistic items, particularly where you can identify when something was made or who it's made by. But for more historic materials, that's problematic because they're already out of copyright. And I was wondering, are we talking about a difference between what is legal copyright and intellectual property rights and what is cultural ownership?
Okay, thank you for the question, Martin. For me, I am looking at both sides of what I would call the divide, in terms of saying, obviously there would be instances where it's just a photograph that you've taken to represent an existing material, and it's just a photograph, and there's no creative input, to borrow your language, in that space. But there would also be instances where there are creative decisions that are made, to the threshold of copyright protection, where you make creative decisions that then result in you creating possibly copyright protected content. When you use a material that's and it doesn't have to be cultural heritage material, but when you use material
Thank you very much. We have another question by Henry, and we can probably quickly summarize this. When you say cultural heritage materials, what are the materials that you are addressing? Henry, if you would like to expand on the question, absolutely feel free to take the stage.
I've had opportunity to be in one or two seminars where there was a presentation by Digital Benin. They had to, and I think that's an info. I think she's German. On her presentation, so they've been they've always been using this term digital cultural heritage material. So I'm asking, in the context of your presentation or in the context of your work, what exactly do you mean when you say cultural heritage material? Are you talking about artifacts? What exactly are you addressing at this point? Say cultural. Then I have another question, but while you respond, I'm about to put it in the chat so I can allow you to. It's okay. Thank you.
Okay. Thank you, Henry. Artifacts are included in my reference to cultural heritage materials. The cultural heritage materials could also be from the perspective of intellectual property law, could also be traditional cultural expressions, could be traditional knowledge, could be indigenous knowledge, insofar as it has that cultural context embedded in them, and where they are in a form that we could experience them with any of the five senses, then we look at them as being in material form. And that's also something that has generated its own debates. Like when you now have digital cultural heritage, materials in digitized form, you can see them, you can actually touch them if you maybe print them out, for example. And so there's now like, okay, who should have control and ownership and custody of, the digitally treated cultural heritage materials, in terms of then deciding who has access, and then what about the cost of housing them in a repository, managing them, and ensuring that they continue to be available for people to access and use and experience, and all that, because that's also something that comes with ownership and control and custody. Yeah.
Thank you very much. Henry, would you like to follow up with your second question?
Yes. Thanks for throwing that light. Chijioke, very very interesting points there. So now I have very good clarity or understanding because I'm actually working on cultural heritage. That's my research in my PhD currently. So my supervisor asked me to join. So that's why I'm here. And I can say your presentation has been very, very helpful for me. Basically, very, very helpful. So I just wanted to, I had already typed the question already, but by the time I finished talking, I could not find it anymore. So I'm going to say it out. One area, like I'm still trying to find out, I'm not sure, maybe you know, because I think you've gone far in your research. Do you think, for example, looking at Digital Benin project, the one from the Dutch project they've done on curating, doing a repository, a platform for some of the artifacts, the works from the probably the return stolen, or let me say, the repatriated works from the looted works from the from Europe and the US and the likes of them. So, what do you think? Like, in your research, do you think the government has created a policy that has been able to, to checkmate the use of these items or this object or these materials? You think that there's a current policy, or the government is not interested, or they're just really interested in first ensuring that this object comes in first? Because you're looking at copyright, so do you think even the country, because you're talking about copyright, do you think the government itself has been able to create policies, especially in Nigeria, looking at what the Digital Benin has done?
So I think it's a work in progress. I think that so far the government has mostly focused on receiving the repatriated materials, which is also like part of my argument that the focus has been on the process of the receiving countries, in this case Nigeria, then receiving and collecting repatriated cultural heritage materials, into the country. But there's not this appropriate engagement with how those materials will then be managed when they are now inside the country. You will see in the chat that I've shared a blog post that I wrote on an article that was written by Desmond Oriakowa, who is Bini himself, and a good friend as well. But he spoke about, or he wrote rather, about the questions of copyright when it comes to the tussle even between the Edo State government, the Benin Kingdom, and also then the federal government of Nigeria as well. So that also remains. And I think that one of the reasons that it has been that way is because of the lack of rigorous thinking around when we receive these materials, then what, in terms of like internally in the country.
Thank you very much. Very insightful. Yeah, that question you left hanging, it's something we need to start asking ourselves. Then what? Then what? Thank you very much, Chijioke. Thank you.
Thank you so much. We have, I think, 2 questions by Harriet. Harriet, would you like to pose the questions on video? Would you like me to read them?
Yeah, I'll speak to my questions, and let me see if my video works.
Hi, Harriet.
Hi, thank you so much. It's such an interesting overview and really great to be talking about repatriation and archives in this exciting way. I think for me, what I'm quite interested in is how do we relate kind of, let's say, licensing or other kinds of agreements to what happens in copyright law. Because often when you see copyright law being amended to include sense of community ownership, there are other factors there, a bit like the Kenyan Act, for example, has got a compulsory licensing aspect to it. And there's sometimes lack of clarity about who makes decisions for the community and what they're agreeing to even in copyright systems that kind of recognize community rights at some level. So my feeling is that there is a place for licensing, and I'd just like you to talk a little bit about whether you think your Noodle license, which I understand is primarily designed around language, might be play a role, something like that, or something like these local context TK labels. I mean, do you see any kind of other sort of features that could be added to copyright reform?
Okay, thank you. Thank you, Harriet. So you would see that I briefly touched on licensing because of the fact that I co-developed the Noodle license. One of the things with the Noodle license is that it starts from the perspective of openness, of being able to provide a mechanism that allows people who want to actually share or provide access to whether it's cultural heritage materials, whether it's African language data sets, whatever. But they've decided already that they want to share, they want to provide access. So it sort of like leans already into the whole preservation access, landmark and approach to looking at providing access to, materials, whether they are copyright protected or whether they are in the custody of someone who gets to make decisions around people having access to it. But it then brings in the whole agency of local communities by then thinking about open for who and how are you making access open. And so it then integrates community decision making in terms of the community involved being able to say, we would like to provide access, maybe in exchange for something that is also valuable to us as much as whatever you're asking for access to would be valuable to you. And then requiring people who could actually provide that material in exchange to be able to do so or to have a mechanism to do so. So for the Noodle license, it doesn't demand anything further from the community itself, because already the community is part and parcel of the whole co-creation of, in this case, what would be language data sets. But it then requires people from developing countries who have the means and, the wherewithal to actually, provide something in exchange that speaks to the needs of the local communities, that speaks to what the local communities are about. And so licensing very much has a place in this whole conversation, and it goes beyond copyright. Because one of the arguments for us as well, even with the Noodle license, is that sometimes the conversation around custody and ownership is not about copyright. It's about, other things beyond copyright. It's about custody. It's about control. It's about, something that is innate to you, that is part and parcel of your person or as a community, right? Part of your identity as a community. And going from that to TK labels as well, that's also another mechanism that could work both as complementary as a complementary mechanism to licensing, for example, or as an alternative mechanism as well. But whatever mechanism that recognizes the agency of local communities, we should all be for it.
Thank you very much. Do we have any other questions? Again, feel free to use the chat, or you can simply unmute yourselves. For people who are interested, I have posted the book chapter that Chijioke's referenced throughout the seminar, and that's open access. You can read it, and you're highly encouraged to do so. And there is a link to the rest of the Material DH seminars that are upcoming and past already for this spring of 2025. We have any more questions from the audience? I do actually have a small curiosity for you, Chijioke, just in light of the previous seminars that we held as well. I'm curious to sort of dive a bit more into the complexity of what happens when the principles of preservation and openness and access conflate very strongly with the interest of a local community. So, for example, in one of our previous seminars, we talked about material that maybe should not be given access, or maybe it should be more protected from, digital reproducibility rather than preservation. So I'm thinking materials that are covered by specific community taboos, or that refer to local knowledge that maybe should not be widely open, not to mention, of course, human remains and things like that.
So this is like, I think your question actually also makes the point about the imperative and the necessity of having agency as, as a strong complementary landmark for deciding on the role of memory institutions, deciding on how access and use of, cultural heritage materials should happen. Because if we just, in this case of, materials that should not be permitted for access to by external actors, or, taboo materials, sacred materials, human remains, and all that. If we just focused on preservation and access as what guides us in deciding what should happen in that space, we might just grant access because we feel that this is important enough to be preserved. It's important enough for people to have access to engage with it and. But when we think about involving local communities, they would be able to guide us and tell us why, and why this should not be the case for this particular kind of material. And so when you have those landmarks conflate and work, together, what you would then find is that you make better decisions about access. You make better decisions about who gets access and when and how the access is controlled and managed.
Thank you very much. And for those of you who don't know, we did reference this very, very complex topic in one of our previous seminars as well. And you're more than welcome to go and watch the recording. This was Rebecca Khan's Skull, Skin, and Names, which happened on March 5th. Are there any more questions from the audience or in the chat? Okay, so thank you very much, everybody. We're just right at the hour. Thank you very much to our speaker, Professor Okorie, and thanks very much to everybody who attended the seminar. Feel free to join us in all of the upcoming events, of course. And thank you very much, and have a good rest of your day.